Hi, I'm Gina Chevalier, your South Florida estate planning, probate, and guardianship attorney. And today I want to talk to you a little bit about estate planning myths. I get a lot of questions, and you would be surprised at some of the questions that I get, but maybe it's something that you're wondering about. So I'm here today to talk to you about those common issues. So let me tell you about one of the common myths and questions that I get. If I don't have a will, my assets are going to go to the state. Nope. That's not the case. I'm here to tell you that the state of Florida has laws put in place to make sure that we designate your assets to certain beneficiaries. The next myth I want to cover is, I have a will. Why do I have to go to probate? Well, I'm here to tell you, unfortunately, a will does not avoid probate. A will simply sets out your directions and your instructions for what you want done when you're not here. That will has to go to the court and be proved. So yes, your will still has to be probated. Another common one going along with that is, I have a trust. We have a trust. Why do we need to go through probate? Well, perhaps your assets were not retitled in the name of your trust. You didn't designate your trust as a beneficiary of your assets. And now we have to go through the probate court to get those assets into your trust. So the next myth I want to debunk is, I'm the executor, I'm the trustee, I get to call the shots. Well, fortunately or unfortunately, that's not the case. It depends which camp you're in. I'm here to tell you that you have to follow the instructions that are given in the will or the trust. And even if you don't like the person or you don't think they deserve it, you still have to follow those instructions. If you can't, then resign as trustee or personal representative. So another common issue that happens is that people think that with a power of attorney, they can continue to act after the person has died. Unfortunately, that's not the case here. If you're going to a bank with a power of attorney after somebody has died to try to find out who the beneficiaries are, the bank's going to tell you, sorry, that's a useless piece of paper. We can't use that to tell you or give you any information on this account. And this next myth sometimes hurts. My mother left my child as beneficiary to the life insurance policy. I'm the parent. Why do I have to go through probate court to get access to funds for my child? Well, in Florida, we have a law that says if a child is inheriting more than $15,000, you have to go through a guardianship. Here's another myth I'm going to debunk that might not be so pleasant. Your child inherits from their grandparent. You're the biological parent, the natural parent. You believe that you have control over that minor's property. But I'm here to tell you that the state of Florida says if that inheritance is over $15,000, you will need to go through a guardianship of the property of the minor in order to obtain access to those funds. And it will stay there until that child turns 18. So here's another myth that unfortunately affects a lot of people. You have a couple, they're married, and unfortunately, only one of them was entitled to the property. The surviving spouse comes to see me and says, well, I get the asset because I'm the surviving spouse. Unfortunately, that's not the case. You still have to go through probate. So I can go on and on about the myths associated with estate planning. You can ask my husband. Unfortunately, he has to hear it. But the reality is there are so many things out there that people just are unaware of. When you're ready to have a conversation about that, or if you need to speak to someone, it's really important that you reach out to a licensed attorney that practices in this area and really understands the situation and knows what they're talking about. When you're ready, give my office a call.